The jury has spoken. An $83.3 million verdict against Donald Trump in the E Jean Carroll defamation case. $7.3 million in compensatory damages, $11 million in reputational damages, and dropping that hammer, $65 million in punitive damages against Donald Trump. As I said, a total of $83.3 million. You see right there, E Jean Carroll with her lawyer, Roberta Kaplan, leaving the federal courthouse victorious. Justice prevailed. Donald Trump was defeated. Will Donald Trump now stop tormenting E Jean Carroll as he was even doing during the trial? And now that this verdict has been entered, Alina Habba's out there whining. What happens next? We'll break down the process of if Donald Trump appeals, he's going to have to post a bond. What's that going to look like? We will keep you posted on all the updates. Next, we also expect that Donald Trump will get hit with another verdict next week in the range of $370 million to $500 million in the New York Attorney General's civil fraud case. And he will also be banned from ever doing real estate business again in the state of New York. Engoron, Justice Engoron, the judge presiding over the case, is expected to make his final ruling this upcoming week. And just in time, the Second Circuit Court of Appeals issued an important ruling on a case involving Martin Shkreli. Remember that guy? Pharma Bro? And the decision by the Second Circuit there has now become persuasive and powerful precedent that I think will defeat Donald Trump's chance of ever succeeding if he tries to appeal the judgment in the New York Attorney General case that's about to be entered. So, Michael Popok, we're looking at about $500 million in judgments against Donald Trump, as you and I predicted here on LegalAF, which will likely be entered before February 1. Should also be noted that the financial monitor who's been overseeing Donald Trump's finances in connection with the New York Attorney General civil fraud case, retired federal judge Barbara Jones, just in time as well, sent a letter to Justice Arthur Engoron, a 14-month report, a 14-month look back on her review of the Trump organization with massive red flags that she is informing Justice Engoron of. We'll talk about the implications of her letter. Donald Trump, desperate for a distraction, filed a motion to disqualify Fulton County District Attorney Fani Willis. Trump always joins these things late, right? Like after the evidence and facts have now come out, making it increasingly clear that this whole thing with Fani Willis is much to do about absolutely nothing. They unsealed divorce records. It showed absolutely nothing. And it's all this MAGA nonsense. Then Donald Trump goes, you know what? Maybe now I should join in the motion to try to disqualify and get her dismissed, because Donald Trump's a loser and he likes to whine about losing, and his timing is always the worst. Also, all of the judges, including the right-wing judges of the D.C. Circuit Court of Appeals, unanimously rejected Donald Trump's petition for an en banc rehearing of the gag order that was imposed on him by federal judge Tanya Chutkan in the D.C. criminal case, then affirmed mostly by a 3-judge panel in the D.C. Circuit Court of Appeals. Donald Trump said, hey, maybe can all of the judges now, of all the judges who comprise the D.C. Circuit, hear this? And all of them were like, none of us want to hear this. Please go away. But still, the 3-judge D.C. Circuit Court of Appeal panel that is hearing the absolute immunity appeal by Donald Trump, they have not yet ruled, which I was expecting this past week. This next week would be the latest I would have expected that to drop. So we'll see if they issue their order regarding Trump's absolute immunity appeal next week. But Popok, could you imagine if they deny Donald Trump's absolute immunity appeal next week? Judge Engoron enters a close to a $500 million order judgment against Donald Trump. The E Jean Carroll verdict, and all of that happens before February 1. A lot happening.
Yeah. Donald Trump's not the only one that tries to time his filings in order to for maximum impact. I am sure Judge Engoron, with special delight, is putting the finishing touches now on his whether it's $300, $400, $500 million decision against Donald Trump and to ban Donald Trump from the real estate industry for life in the New York civil fraud case. Now, having seen how Judge Kaplan handled his courtroom, we'll go into that in detail, during the 1-week trial, Donald Trump acting out and flouting the rules again in the courtroom, but a jury standing by ready to punish him. The whole trial of E Jean Carroll was about sending a sufficient punishing message through punitive damages to stop his misconduct, for which Donald Trump, in the courtroom, outside the courtroom, and during the trial, could not help himself but continued to perform misconduct in front of the jury, which only led to a much higher amount than they would have had he just played nicely in the sandbox and colored within the lines. And when we get there, Ben, we'll talk about on the 3-judge panel thing. Yeah, that's got to come out. I'm beyond tapping my foot on this one. It is obvious to me, and when we touch on it, when we get to that segment, that 3-judge panel on absolute immunity in the D.C. Court of Appeals, led by Judge Pan and then Judge Childs and Judge Henderson, are struggling to get the votes around how they're going to deny Donald Trump's appeal. I don't think the struggle that we're watching, in the sense that it hasn't come out fast enough, the struggle is not over. There's a holdout, and there's maybe a majority to find absolute immunity for criminal conduct while somebody's in office. The struggle is how to write this and how to thread the needle and get all the votes together for a combination of jurisdiction. Do we have jurisdiction? And then a combination of, and then do we need to send it back to Judge Chutkan for anything, or can we just declare once and for all there's no absolute immunity? They're struggling with it, knowing the historic moment. We're watching the struggle in the sense that this is why the order has not come out. Once we see the order, you and I and Karen will be able to pick through it, and we will know exactly what the conflict was and how it was resolved by way of this majority decision that we're waiting on.
I think you and I both agree that the outcome will be Donald Trump does not have absolute presidential immunity. But to your point, the delay is likely being caused by these technical issues, the jurisdictional issues. Do you have to remand for certain technical questions to be answered by federal judge Tanya Chutkan as to each specific act? Or can you just kind of sweepingly just say this absolute immunity thing is just totally without merit? Those types of questions are probably what's being discussed, but I have no doubt, or I feel very confident, I should say, that they're all in agreement, or at least the majority of the panel is what you need, is in agreement that there is no absolute immunity. We'll get to that a little later. To your point on Judge Engoron, I just think he was waiting for that report. He asked for that report from retired Judge Barbara Jones. And I think when we hear about Judge Engoron's order, yes, the headline's going to be the amount, somewhere between $370 million, but with pre-judgment interest and penalties, it'll probably look closer to $450, $500 million. But I think that what's going to be talked about a lot, and we'll go through this when we talk about the Judge Engoron section and his potential ruling, there's going to be a lot of discussion on his view about Donald Trump's ongoing behavior of fraud, the persistent systemic fraud that was identified in Judge Barbara Jones' report, Trump's ongoing behavior. And I think some of the big headlines is going to be that Donald Trump, even during the trial, posed a systemic threat to the financial system, as evidenced by reports by the Monitor. And that brings us, and it's a nice segue to talk about what happened in the E Jean Carroll defamation case, because rarely do you see somebody on trial that in a criminal case continues to commit the crime while they are on trial, or in a civil case, which the E Jean Carroll case was a civil case for monetary damages, do you see a person who's on trial for defamation continuing to defame and continuing to behave in the way that they were accused of, right? Most defendants, even when they did the underlying act, try to at least pretend that they didn't do that or they don't act like that. And they're not going to keep on giving evidence to the person that's suing them or give evidence to the prosecution. But this was such a unique situation where during the trial, Trump would be posting defamatory statements about E Jean Carroll. E Jean Carroll's lawyer, Roberta Kaplan, would then be showing it to the judge and saying, I want to admit this into evidence. And then it would be admitted into evidence. Ladies and gentlemen of the jury, he just did it again. When? Just now, moments ago, you witnessed the defamatory statements live in real time in this court. So no doubt that was a major aspect of the jury's verdict. And E Jean Carroll's lawyer, Roberta Kaplan, and Sean Crowley made that very clear in their closing arguments as well, that that's what was going on, and that's why you needed to send a message. Here are my takeaways, Popok, and then I want to throw it to you. Number one, the entire defense by Donald Trump through Alina Habba was horrifying, was sickening, was disgusting. Alina Habba went there during the opening statements and closing arguments and argued E Jean Carroll should be happy. This is what she wanted. Donald Trump gave her what she wanted: fame and attention. So really, Donald Trump is the victim here, which is the routine that these MAGAs do on their right-wing networks. But that's a horrific argument. That's like a horrific thing in a court of law to say. It's horrific to say anywhere. But she tried to bring that MAGA Trump cult stuff into a court, and it didn't play, and say the victim of a rape should be happy because her rapist gave her fame and keeps giving her fame by defaming her. And E Jean Carroll's lawyers said what I just said to the jury. How horrifying. Can you believe that that's what they are actually arguing to you today? That's what they're arguing. Two, Trump's behavior in the courtroom, storming out, speaking under his breath, showing contempt for the jury, walking out before the jury walks out, just acting like a complete maniac in the courtroom. Three, Alina Habba was just the worst lawyer ever from every aspect of it. She was not likable and she was incompetent. She couldn't do basic things like introduce evidence. She doesn't know what admissible evidence even is. She doesn't know how to lay a foundation. She couldn't perform the most basic functions of being a lawyer. Four, as I mentioned, evidence created during the trial. Five, the judge controlling the courtroom and showing a roadmap for how you control your courtroom. When Donald Trump tried to speak out loud, Judge Kaplan would yell at him and say, "Be quiet, Mr. Trump. This is my courtroom. Understand what I'm saying. Be quiet right now." And Donald Trump would listen. And he would put Donald Trump in his place over and over again and would not let this become a circus-like environment. And finally, number six, E Jean Carroll, her courage and the competency and just exceptional nature of her lawyers, Roberta Kaplan and Sean Crowley, who were A-plus lawyers and delivered just an incredible opening and closing. How much money is it going to take to make him stop? And you're going to have to decide that, because he needs to stop this behavior. Those are my takeaways. Popok, let me throw it to you.
Well, yeah, I agree with everything that all the five things that you just said. You've got a judge, you got a collision here between a federal judge with empowered and with all of the endowed with all the powers of a federal judge, who knew who his enemy was, in the sense of a defendant that was going to act out, was going to be contemptuous or contumacious, was going to be disrespectful to the process, to the system, to the administration of justice, to the jury, and everybody else knowing that because of what happened. We all had a dress rehearsal back in April and May, a similar but not identical trial, but about liability, about whether E Jean Carroll was raped by Donald Trump, and a jury of 9 people in May found that she was. And the only issue for this jury, which seemed to be a concept lost on Alina Habba and on Donald Trump, was not about liability, was not about anything other than how big of a check for punitive damages would be written. And when you walk into a courtroom and you're the defendant in a case where the jury needs to determine if they are going to throw the book at you and award punitive damages, having already been instructed day one, including during jury selection, that by the judge, that this is a case about the amount of punitive damages, if any, that you are going to award. You are to assume that Donald Trump raped, sexually assaulted E Jean Carroll, and that he defamed her in the 2019 period when he was president and thereafter. And you are to take all of that into account, including his intent to harm her, with prejudice against her, with animus against her. Those are the factors that the jury had at its disposal from the moment they walked into a courtroom. And you and I have talked a lot about on LegalAF over the last 3.5 to 4 years, our faith in the jury system. And we saw it play out here. I know that Robbie Kaplan, the lawyer for E Jean Carroll, is now on network television. Hopefully we'll get her back on the podcast again. Is also declaring her faith in the jury system. They sent a message to bullies everywhere that they will be held accountable. And if you try to do, this is now the second example of this with Rudy Giuliani a couple of months ago, also acting out in front of a jury, doing things inappropriately in real time that was brought to the jury's attention, continuing to defame the people for which he was on trial for same thing, defamation damages, punitive damages included, and the same result. He got a $148 million hit from a DC jury. This one, by the way, right on the money, not just what we've predicted, but right on the money of where a jury needs to be in order to have its jury verdict upheld ultimately through a trial and an appellate process I'll talk about in a minute. That $65 million in punitive damages against the $28 million in actual damages, if you will, is so perfectly calculated to survive an appeal. I know all these nutty MAGA people are up on social media saying she'll never see 1 cent. You're right. She's not going to see 1 cent. She's going to see whatever the total is for $83 million worth of cents, and that is going to get paid. That the process now. That people should understand as we manage expectations or set expectations is that judgment will become final in about 30 days. Sure, Alina Habba is going to file a motion for remittiture or vacatur, which means to have the judge take away from the jury and lower the number or eliminate the jury verdict. He's never... Lewis Kaplan, the judge, having watched Donald Trump act inappropriately and teeter on the edge of contempt and mistrial for most of this case or all of this case, is not lowering the number. He also has the power to raise the number, by the way. So Alina Habba, when she asks for less, look for Robbie Kaplan to ask for a bit more and see what Judge Kaplan does in terms of it. Now, I don't think he takes it away from the jury. I think he's going to affirm and confirm the jury award. Once he does that, that judgment becomes final, and they can go enforce that judgment and show up with a sheriff at bank accounts, which we know where they exist because the Barbara Jones Monitor has, we know where all the bank accounts are, unless they file an appellate bond to take another appeal, like they did in the first case for the $5.2 million. But this time, it's not just coming up with cash, which is chump change, and I mean literally chump change because he's taking it off the chumps that support him. That Donald Trump never pays for his own, doesn't pay for his own bills and legal bills or bond posting. But that was $5.2 million plus interest, plus another 10%. This is more. This is $83 million. So he's either going to have to get and go through the monitor to get it, ultimately, supply proper financial statements, oh, what a tangled web we weave, to a bonding company and try to get a 10% bond and only have to put up 8.3 million, or let's say 10 million, and then have the bonding company be on the hook for the rest. I don't know what bonding company, knowing that Donald Trump is committed persistent fraud in the state of New York as a judge by a judge, is going to do a bond for him, or he's going to have to come up with the 83 and change plus another set of interest, probably closer to 100 million, and put it into the court registry in order to stop the enforcement of that, while he takes it what will ultimately be a losing appeal to the Second Circuit Court of Appeals on his way to the Supreme Court again on whether he had absolute immunity. Alina Habba, you did a great job on your hot takes, and we'll talk about it more here. It just is this constant harangue that she used, that she intoned and berated the jury with about First Amendment and blame the rape victim, and the rape victim had it coming, in other words, and the rape victim is profiting from this, and you shouldn't give her more money. She's made so much money because she was raped by my client. I mean, this is just mind-boggling bad. And the jury, which, as I started my analysis here, juries hate being lied to, being found that you're inauthentic and that you're talking down to them and patronizing them. And I assure you, having worked with juries for years, this jury despised Alina Habba, despised the muttering, unhinged ramblings of Donald Trump. Alina Habba was shot down by the judge in front of the jury half a dozen times for doing things that were inappropriate, including being warned that she was teetering on the edge of sanctions and contempt. Juries follow the leader being the judge wearing a black robe. They look for direction from that person. That's their boss, if you will, while they're sitting there doing their civic duty. I'm sure they had a lot of respect for Judge Kaplan. And when a judge looks at a lawyer and says, "You're effing up in my courtroom," juries take notice. And when you're trying to calculate punitive damages, as you said, Ben, that defendant should be like a halo. They should be wearing like their best clothes and look prim and proper and just shut the F up in court unless you're testifying at that moment. But that's not Donald Trump's approach. He already had an example of what not to do with Rudy Giuliani and what a jury could do in response. But that didn't stop him. So he took a $5 million judgment from the summer, and he, by his own misconduct and his lawyer's misconduct, turned that into an $83 million judgment with a brand new jury in New York. One last comment, Ben. Merrick Garland should get credit also here for what he finally did in terms of taking the position ultimately that there was no presidential immunity that would allow the United States to intervene in the case, to take Donald Trump out, and therefore seek the case's dismissal. There was a period for about a year we were wondering what Merrick Garland was going to do with the E. Jean Carroll case. If he had stepped in and said, well, that looks like it's inside of presidential immunity and his scope of authority to have made those comments while he was president of the United States, so for future precedent, we're going to step in, that would have killed this case in its tracks and set a terrible precedent that the DC Court of Appeals and Supreme Court are dealing with now about immunity for civil and criminal acts of Donald Trump. So shout out to Merrick Garland. We would not be talking about an $83 million judgment for E. Jean Carroll if he had asserted, if you will, presidential immunity and taken Donald Trump out of this case.
You know, it's a hyper-technical immunity issue, which we could write hyper-technical textbooks about it. Suffice to say, there's a statute called the Westfall Act where the Department of Justice can assert that underlying conduct falls within the course and scope of presidential duties and therefore substitute in the United States as a defendant or party in the case in place of the government official. Bill Barr tried to do that. As the facts developed, Merrick Garland ultimately decided not to do that. But because Alina Habba was so incompetent, she could have, independent of that process, asserted absolute presidential immunity as an affirmative defense, independent of what the Attorney General would do or not do to still be able to try to make that argument. She failed to basically check the box and put that sentence in the answer, which you would literally just say, Donald Trump hereby asserts absolute presidential immunity. So when that issue more recently went before the Second Circuit Court of Appeals, they laughed Alina Habba out of court and said, yeah, you're about 3 years too late for this. And also in Alina Habba's press conference that she had after the trial concluded, where she was whining about things like the judge wouldn't let my experts in, the judge wouldn't allow the dress to come in, the judge wouldn't all blah, blah, blah. The reality is that Alina Habba waived all of those things. She, based on her bad lawyering or Donald Trump's decisions, they never turned over the DNA on time, which they could have done, and they could have made that an issue. It would have related to the first trial, not this trial, but they never turned that over on time. She waived the expert. She didn't file the declarations on time. She didn't designate appropriate experts. It was disqualified because she just didn't follow the most basic fundamental rules of civil procedure. And it was clear when she was in trial that she's just a very incompetent person, and Trump surrounds himself with incompetent yes people like Alina Habba. And afterwards, she posted something like, "Let's go MAGA. This is not the end of this. We're just getting started." Like, just getting started with what? Losing more? I could only hope that she takes a more robust role on all things Donald Trump. Final thing I want to mention, federal judge Lewis Kaplan gave a warning to jurors. He's treated this case like a mob boss case, like a mafia case, as though you had El Chapo in front of him. He said, I'm going to give you a warning. You can do what you want to do here, ladies and gentlemen of the jury, but I would suggest strongly you tell nobody ever that you served on this jury, because you could be in danger. So do not tell anybody. And the way he conducted his court, federal judge Lewis Kaplan, was that of a mafia trial. So Popok, to your point, Donald Trump will now have to post a bond. E Jean Carroll, unless Donald Trump doesn't post a bond, if he doesn't post the bond, E Jean Carroll can start collections right away. If Trump posts the bond, it stays the collections pending the appeal. Trump will inevitably lose the appeal. That may take a year to kind of work its way through the courts. But in terms of when I would expect E Jean Carroll to be paid as it goes through the appeal process on both cases, I mean, you're probably talking about in 12 to 18 months to about 2 years, she'll get paid. But Trump is going to have to pay that money. He's not going to be, he's not going to be able to wiggle out of this one. I think you and I both agree. When we come back, let's talk about what's going on with the New York Attorney General civil fraud case. We expect a verdict to be reached there, an order by Judge Engoron or Justice Engoron. Next week, we'll talk about the amount. We'll also talk about this report by retired federal judge Barbara Jones about her 14-month review of the Trump Organization, where she found errors and inconsistencies and omissions and phantom loans all during the past, 18-month period or 14-month period where she's been overseeing it, just in those 14 months alone while the lawsuit is pending. We'll talk about that and more. Let's take our first quick break.
What you feed your dog goes a long way to helping them lead their best lives. Nom Nom delivers real, good food, backed by science to help your dog thrive, because everything from strong digestive and immune systems to high energy starts with what's in their bowl. Nom Nom delivers freshly made dog food with every portion personalized to your dog's needs, so you can bring out their best. Nom Nom's made with real, wholesome ingredients you can see and recognize without any additives or fillers that contribute to bloating and low energy. That's because Nom Nom uses the latest science and insights to make real, good food for dogs. Their nutrient-packed recipes are designed by board certified veterinary nutritionists, freshly made and shipped free to your door. Nom Nom's already delivered over 40 million meals to good dogs like yours, inspiring millions of clean bowls and tail wags. I feel so much better knowing that I'm giving my dog Lily better nutrition, and my dog really loves it too. Plus, Nom Nom comes with a money-back guarantee. If your dog's tail isn't wagging within 30 days, Nom Nom will refund your first order. No fillers, no nonsense. Go right now for 50% off your no-risk 2-week trial at trynom.com/LegalAF. Spelled trynom.com/LegalAF for 50% off. trynom.com/LegalAF. Don't reinvent yourself for the new year. Just rehydrate yourself with Liquid IV. With 3 times the electrolytes of the leading sports drink, plus 8 vitamins and nutrients for everyday wellness, Liquid IV hydrates 2 times faster than water alone. All in a single sugar-free stick. So you can feel like a hydrated new you ready to take on 2024. I love how Liquid IV makes me feel. Also, the packaging is super convenient and makes it easy to carry with for when I need it most. My favorite flavor, white peach. It's robust and super satisfying, but you can't go wrong with green grape and lemon lime either. 1 stick plus 16 ounces of water hydrates better than water alone. And there are no artificial sweeteners and 0 sugar. It's non-GMO and free from gluten, dairy, and soy. Rehydrate yourself for the new year. Grab your Liquid IV Hydration Multiplier, sugar-free in bulk nationwide at Costco, or get 20% off your first order when you go to liquidiv.com and use LegalAF at checkout. That's 20% off your first order when you shop Better Hydration today using promo code LegalAF at liquidiv.com.
We are back live on LegalAF. We expect next week that Justice Arthur Engoron is going to issue his order. The New York State Court judge, Justice Arthur Engoron, will issue his order after the significant trial that took place before him. That was a bench trial. It was not before a jury, although for all of Donald Trump's complaining that he would have liked to be before a jury, Trump keeps on losing over and over again whenever he's before juries. But Justice Engoron previously announced that he was going to release his order sometime before February 1st. New York Attorney General Letitia James is requesting approximately $370 million in damages against Donald Trump and the Trump Organization, also requesting injunctive relief to stop or bar Donald Trump from ever conducting business again in the state of New York, especially in the real estate sector, and seeking a 5-year ban on Don Jr. and Eric from being involved in real estate. New York Attorney General Letitia James has already prevailed regarding her prior claim as to the dissolution of the Trump Organization, where Justice Engoron ruled in the favor of the New York Attorney General's office that based on the systemic and persistent fraud and the fact that there were no disputed facts that the Trump Organization would be dissolved. That's currently under appeal, but that's paused while we wait for Justice Arthur Engoron's order here as to the remaining causes of action, which include the disgorgement, the return of ill-gotten gains. That's what disgorgement is, return of that money that you basically took improperly from the state of New York based on your conduct. And to that, Letitia James is requesting $370 million, but when you add the pre-judgment interest at approximately 9 or 10% per year compounding, you can get up to around $500 million when you add up the total of the interest, plus penalties, plus the $370 million New York Attorney General Letitia James is requesting there. And we expect that order to be handed down next week. So 2 major developments, though, in this past week that I think are very worth reporting. Both are going to be helpful to New York Attorney General Letitia James and also helpful to Justice Arthur Engoron in crafting an order that will survive appeal. First, there was a Second Circuit Court of Appeal decision that was reached in a case involving Martin Shkreli. You remember Martin Shkreli? He's the farmer bro. He went to jail. He testified before Congress and invoked the Fifth, and he had raised the prices of various pharmaceutical drugs like the antiparasitic Daraprim to like 1,000% higher than it should have been. But anyway, under the New York Attorney General statute that is used against Donald Trump. It was the same New York Attorney General executive law used against Shkreli, and Shkreli's appeal of the utilization of that law that fined him around $65 to $75 million in disgorgement damages, whereas New York Attorney General Letitia James is seeking $370 million disgorgement damages from Donald Trump, and whereas Shkreli has been banned from the pharmaceutical industry, New York Attorney General Letitia James is seeking to ban Donald Trump from the real estate industry and from doing business in New York. So Shkreli's appeal and Shkreli's case worked its way through the federal courts, not through the state court system, but nonetheless, Shkreli was challenging this executive law that's used by the New York Attorney General, saying it's unconstitutional, it's improper, all of the arguments you'll expect that Donald Trump makes about this law. Notably, one of the things that Donald Trump says too, right, which is false, which we've dispelled, is that this law has never been utilized before. They're targeting me with this law. This is the first time New York Attorney General Letitia James or a New York Attorney General has used it before. That's not true. It's been used actually quite, not with a great degree of frequency, but it's been utilized a lot by the New York Attorney General's office over and over again. In fact, Donald Trump's own expert in the New York Attorney General's civil fraud case testified in one such case that was brought by the New York Attorney General. So this has been utilized before. So the fact that Shkreli lost in the Second Circuit Court of Appeals, where they said, nope, we affirm the district court's ruling that this statute by New York that's being utilized by the New York Attorney General is proper, that the remedy here of disgorgement against Shkreli plus the permanent lifetime ban from the pharmaceutical injury is appropriately tailored. That's beneficial to New York Attorney General Letitia James. If you've been following LegalAF, we've talked about it here in the closing arguments. The New York Attorney General's office referenced that case, but there had yet to be a ruling by the Second Circuit Court of Appeals. And in fact, it would have been very bad to the New York Attorney General's office if the Second Circuit struck down that law and said it was improperly used with Shkreli. But as soon as the Shkreli decision was just handed down, what did New York Attorney General Letitia James do? Like any really good lawyer, immediately sent a letter to Justice Arthur Engoron informing Judge Engoron of the decision reached by the Second Circuit. Now, the Second Circuit is not the appellate division in the state court system. It's in the federal system. So this is not binding authority on Justice Arthur Engoron, but we call it in the law persuasive authority. And the fact that it's happening in a federal court in New York, I would say it's powerful, persuasive authority that shows that the New York Attorney General has the authority, and it's a recent case, to do the exact remedy that she is seeking against Donald Trump. So the Shkreli ruling, I think, was a big one right there. And then we get this Barbara Jones letter. The retired Judge Barbara Jones, the independent monitor, who was appointed after New York Attorney General Letitia James prevailed in an injunction back in 2022. Judge Engoron found Trump was engaged in ongoing issues and ongoing financial machinations that required somebody to oversee what was going on. And Popok, you read this letter by Judge Barbara Jones here. This is an independent judge. She was selected by Trump. Both parties selected her. This is someone with an impeccable reputation whose job was just to look through the books for the past 14 months. Her job isn't to, she's not a judge, right? She doesn't make the ruling. She just reports on what she sees. And her letter says, she's reviewed for the past 14 months. I've identified certain deficiencies in the financial information that I have reviewed, including disclosures that are either incomplete, present results inconsistently, and or contain errors. In addition, while defendants have been cooperative, information required to be submitted to me pursuant to the terms of the monitorship order and review protocol has at times been lacking in completeness and timeliness. I have previously reviewed these items with the Trump Organization, which has often agreed to modify the disclosures or implement processes that improve accuracy, transparency, and the timeliness of their disclosures. In other words, they're continuing to engage in this conduct. And then you read this footnote, Popok, that talks about footnote 6, where they're talking about inconsistent disclosures, incomplete disclosures, and errors just over the past 14 months. Of particular note, I discussed the springing loan previously disclosed as being between Donald J. Trump individually and Chicago Unit Acquisition, an entity related to the Trump Chicago Tower, with the Trump Organization several times. When I inquired about this loan, I was informed that there were no loan agreements that memorialized the loan, but that it was a loan that was believed to be between Donald J. Trump individually and Chicago Unit Acquisition for $48 million. However, in recent discussions with the Trump Organization, it indicated that it has determined that the loan never existed, and thus it would be removed from any upcoming form submitted to the Office of Government Ethics, and would also be removed from subsequent versions of the MAML, which stands for Material Assets and Material Liability. So a $48 million phantom loan sounds like fraud to me. And Popok, Judge Jones, it's not her job to say this is fraud or not fraud, just to flag what she found. It's for New York Attorney General Letitia James to characterize it a certain way and the judge to make rulings. But this happened since the filing. Finally, before I pass it to you, before all the LegalAFers get upset, Popok was having some technical difficulties on his end, which is why I hogged this category. Otherwise, I would share and let Popok speak. So for anyone in the comments who are saying, let Popok speak, I was doing Popok a solid right there. I'm going to let Popok take the full next topic after we talk about Judge Barbara Jones to make up for it.
Ben does not have a Popok mute button. I assure you, I had some technical difficulties, as Ben outlined. We've got good news that we can report right on target and right about what Ben said to start the podcast. Judge Engoron is going to be issuing his order on Wednesday, the court has announced, of this week, just as we said, waiting for the results of the jury, the federal jury in the E Jean Carroll case, and waiting for this report that we're going over in detail by former Judge Barbara Jones. Judge Engoron is ready to having, I'm sure, as I said earlier in my analysis weeks ago, that he had most of that order written at the time of the closing arguments a couple of weeks ago. That went terribly for Chris Keiss, the lawyer for Donald Trump, and was just waiting to see if there was anything that he had missed in 11 weeks of trial, in dozens of witnesses, in the experts, so-called experts by Donald Trump, and in the thousands of pages of exhibits that he, and yes, shout out to his principal law clerk, that he and his principal law clerk sifted through and coordinated and analyzed for the 11 weeks. It's not judges that are the bench trial judges and not the jurors for fact-finding. Don't wait until the very end in order to start drafting or coming up with their final judgments. They are every day, they are noting things in the daily transcript of that trial about things that will be important to their ultimate decision. And they're making notes and taking notes in real time that end up getting, weaved into their order. So it shouldn't come as any surprise that less than a couple of weeks after the oral argument, he's ready to issue what I expect would be a 15, 20, 25, whatever page, single-spaced, as only Judge Engoron can do, order against Donald Trump upwards, I think closer to the $500 million that you talked about. And now the judge has even more fodder and firepower, because even though the persistent fraud findings are for a period of time and not necessarily up to the moment, the monitoring as a remedy that he installed and will continue, obviously, to keep in place to make sure that there are controls over this New York corporation, unless and until the time when they are dissolved, which is a separate matter, I guess, at the appellate court level. This only gives the judge, and I'm sure he will cite to it, that even today, an organization that Donald Trump still heads and for which his children are still officers and control officers, is not being honest and truthful and forthright, nor have proper controls in place in the company, even at the moment, even to the moment. And that demonstrates that they have no interest or desire to run that organization in a way that's consistent with New York law and the judge's findings. And to your point about the law that the Kelly case, I always get his name screwed up, Pharmabro case that the Second Circuit came down with, although not directly on point, it does talk about the powers of a New York Attorney General or Attorney General to seek both disgorgement and industry banning. That law that she's using has been on the books since 1956. That Jacob Javits, for which there is a convention center named after him in New York, before he was a senator, was an attorney general, and he got that power back in 1956. That's how long that's been on the books. So if you don't like the way New York corporation law works, or you don't like the power of the attorney general, such as the NRA that incorporated in the early 1910s in New York, or Donald Trump's organization, who his father incorporated in New York in the 1950s and 60s, then you move out and you go to states like the Santas land in Florida, if you don't like that, where you don't have to worry about an attorney general going after you, because they don't go after anybody, especially on the MAGA world. But if you're going to stay in New York, this was always been a power. In fact, part of the power of disgorgement was embodied in a case involving the Trump Organization and Trump University. And so, and the ability to declare persistent fraud and the powers that flow from that. So for Chris Kice to continue to get up, they have this broken record. Alina Habba can't stop saying, it's almost like a Tourette's. She can't stop saying First Amendment. Everything is First Amendment. First Amendment right to defame E. Jean Carroll. First Amendment right for my client to say anything he wants that pops into his head in a courtroom. First Amendment right for me to speak and not be banned and barred by the judge. And Chris Kice, the same thing. Everything there is disgorgement is not an appropriate remedy. There's no power to disgorge by way of the New York Attorney General. Look, Chris, I know you don't practice in New York regularly. You're a Florida lawyer, and therefore, I would expect you to be more expert in Florida law, but you don't know what the heck you're talking about when it comes to the New York Attorney General. And if that's going to be your appeal, when the judge nails your client and cites the judge and continues to cite to Judge Jones's monitoring, where she actually said, buried in this 14 pages, Ben, she actually said, I wasn't really charged with figuring out whether they're committing fraud or not. And right. And I can't, and I haven't been hired to do that. And I can't attest that they're not continuing to commit fraud. I can tell you there's control problems. I can tell you they make non-material errors, including the $48 million phantom loan issue, that they haven't come back to me on certain of the errors, that they switched using a statement of financial condition and started using this MAML, this material assets thing, without getting lender approval. I don't know if that's proper or not, and they're still doing transactions behind my back that I have to then find with my team and report to you. This is not a report card that you want if you're trying to convince a judge that you're on your best behavior and you shouldn't be dissolved and you no longer need to have a monitor over you. I mean, listen, I'll be frank. I've been involved with an organization, and it happens in financial services, that has had, other outside agencies that have wanted to put monitors over them and for a short period of time over certain parts of their business. And you better make sure you get a clean bill of health and straight A's on that report card, or you're going to just buy a lifetime monitor. And until this company is either put out of its misery by the judge's order affirmed on appeal that it should be dissolved, because it can't operate in any way other than in a criminal way, in a fraudulent way, then they're going to have this monitor in place for as long as possible.
You go back to the E. Jean Carroll case, he can't stop. Like, that was one of the themes of Roberta Kaplan's close and Sean Crowley's closing argument. He can't, you have to make him stop. he's incapable. There could be other trials. He won't stop doing it unless you make him stop engaging in this defamatory behavior against his rape victim, right? Here in the New York Attorney General civil fraud case, it's a financial argument like that. He's incapable of not committing fraud. He continues to commit fraud over and over again and just can't be stopped. So, Judge, we have to use this law, which was just affirmed by the Second Circuit, because even during the period of the lawsuit, they kept on doing it. And again, while I think one of the headlines here is going to be the number, because the numbers always get lots of headlines, whether it's 370 million with penalties and prejudgment interest, $500 million. We're going to be at $500 million in judgments against Donald Trump by next week, where he's going again to have to post a bond in New York, like he's going to have to post a bond in the E Jean Carroll. But I'm looking for, Popok, the other aspects of Justice Arthur Engoron's order, where he's going to talk about this continuing fraud and what's going to be done about it. Yes, he's ordered the dissolution. Yes, Trump will get banned from doing real estate in New York. But I suspect, just like you and I suspect, that in E Jean Carroll, there may be another lawsuit that's filed, an injunction to ban Trump from saying these things based on these verdicts, another defamation case. I think very quickly we could have another New York Attorney General investigation and case opened up like immediately because of that report that we are just talking about
on
right
that
there.
note, Ben, before you move on that note, Letitia James can walk and chew gum at the same time. She's about to put the NRA out of business under the same set of statutes right now. You know, while the case was dark against Trump, she started her case, not with Judge Engoron, but with another judge, but in the same New York State Supreme Court. And her team can put on two major cases at the same time. That and NRA and Wayne LaPierre are going to be barred and banned from ever doing business in New York again. The NRA tried to already move to a different state and reincorporate in Texas, but there still remains power of the New York Attorney General, and the NRA, which we thought was impenetrable and no harm could ever come to it in a case. Watch Letitia James in the same year as New York Attorney General take down Donald Trump for $500 million, put him out of the real estate business, and do the exact same thing to the NRA.
And like Trump, some of the key witnesses against the NRA were the NRA's own people who talked about the private jets and the yacht known as Illusions, that all of this money that was being donated to the NRA by people that the NRA grifted off of, similar to the way Trump grifts off MAGA, were being used. Private jets, family trips, black car services, high-end gifts for friends and family. I mean, all of that stuff, the parallels there are uncanny, and then someone like LaPierre, was going to whine and go, oh, they're targeting me. No, you're just committing systemic and persistent fraud. And we're going to talk about Georgia in a bit, where there's like no evidence. Don't get me wrong. I think when you're talking about, excuse me language, no evidence against Fulton County District Attorney Fani Willis to try to disqualify her. And as I've said to you, I said it's probably not a great look, but there's no evidence there. I wanted to say, where's the evidence? Because if there's bad evidence that gets released, I want to share that with the LegalAFers out there. But I hope as you look through our presentation of these cases, especially as some of these cases are now reaching part of their conclusions, whether it's the defamation case or whether it is the case, in the New York Attorney General civil fraud case, I hope what you find, though, is that we haven't misrepresented what the underlying facts and evidence are. I believe the jury was going to reach the verdict that it did because that's where the facts and evidence were. I believe that the Judge Engoron is going to reach this because that's where the facts and evidence are. But it's a very fact-based, detailed analysis that leads to these conclusions. So let's talk about what's going on in Fulton County, Georgia, where you have a bunch of MAGA nonsense attacking Fulton County District Attorney Fani Willis. Let's talk about that. And let's talk about what's going on in the D.C. Circuit Court of Appeals. And then we'll go from there. But let's take our last quick break of the day.
Did you know that your temperature at night can have one of the greatest impacts on your sleep quality? If you wake up too hot or too cold, I highly recommend you check out Miracle Made's bed sheets. Inspired by NASA, Miracle Made uses silver-infused fabrics and makes temperature-regulating bedding so you can sleep at the perfect temperature all night long. Using silver-infused fabrics originally inspired by NASA, Miracle Made sheets are thermoregulating and designed to keep you at the perfect temperature all night long, so you get better sleep every night. These sheets are infused with silver that prevent up to 99.7% of bacterial growth, leaving them to stay cleaner and fresher 3 times longer than other sheets. No more gross odors. Miracle sheets are luxuriously comfortable without the high price tag of other luxury brands and feel as nice, if not nicer, than bed sheets used by some 5-star hotels. Stop sleeping on bacteria. Bacteria can clog your pores, causing breakouts and acne. Sleep clean with Miracle. Go to trymiracle.com/LegalAF to try Miracle Made sheets today. And whether you're buying them for yourself or as a gift for a loved one, if you order today, you can save over 40%. And if you use our promo LegalAF at checkout, you'll get 3 free towels and save an extra 20%. Miracle is so confident in their product, it's backed with a 30-day money-back guarantee. And if you're not 100% satisfied, you'll get a full refund. Upgrade your sleep with Miracle Made. Go to trymiracle.com/LegalAF and use the code LegalAF to claim your free 3-piece towel set and save over 40%. Again, that's trymiracle.com/LegalAF to treat yourself. Thank you, Miracle Made, for sponsoring this episode. You know what they say, cold turkey may be great on sandwiches, but there's a better way to break your bad habits. We're not talking about taking some strange advice off a sketchy message board. We're talking about our sponsor, Fume, and they look at the problem in a different way. Not everything in a bad habit is wrong. So instead of a drastic, uncomfortable change, why not just remove the bad from your habit? Fume is an innovative, award-winning flavored air device that does just that. Instead of vapor, Fume uses flavored air. Instead of electronics, Fume is completely natural. And instead of harmful chemicals, Fume uses delicious flavors. You get it. Instead of bad, Fume is good. It's a habit you're free to enjoy and makes replacing your bad habit easy. Your Fume comes with an adjustable airflow dial and is designed with movable parts and magnets for fidgeting, giving your fingers a lot to do, which is helpful for distressing and anxiety while breaking your habit. First time I tried Fume, it was way more flavorful than I thought. It feels very fresh. Fume is light, well-weighted, perfectly balanced, and extremely fun to fidget with. I absolutely love Fume. You got to try the new Solano Fume. It's made with a premium walnut barrel and an onyx-coated mouthpiece that has a slightly softer finish. Right now is the best time to start the good habit with Fume. All orders for the month of January have buy one, get one cores, so you can stock up for that New Year's resolution. Plus, as a listener of the show, you get an extra 10% off when you use our code. Head to tryfume.com/LegalAF and use my code LegalAF for an additional 10% off, plus BOGO cores until January 31st to help making starting the good habit that much easier.
Welcome back. We're live on LegalAF. I want to talk about all this, what I consider to be MAGA nonsense in Fulton County, Georgia, where they were attacking Fani Willis. And I said on the last show, I thought that creating any ability for MAGA to attack you in ways that can be avoidable, I think from my own perspective, it's like, why even give them an issue? You know where they're going to go with these things. It's going to create distractions where they can be avoided. If they can be avoided, avoid them. It has nothing to do with the underlying merits of the prosecution. But then why even create the issue, to begin with when I think it's avoidable? So now Donald Trump is joining the motion by Michael Roman, one of his co-defendants in the case, to try to disqualify and disqualify Fani Willis and get the case dismissed. Popok, I ate up a lot of the New York case while you were having some technical difficulties. So as promised, I'm going to give you this whole topic to break down.
Fresh from Georgia, where I was visiting my mother, so I feel very well prepared for this. So we had reported earlier on LegalAF, and you and I did hot takes on it, that Mike Roman, who, as you touched on, was what I like to refer to as the fake certificate mule, bringing the fake certificates from the 7 battleground states and wending their way through even members of Congress to try to get to Mike Pence and pressure him. He was the election day coordinator for Donald Trump. He's in a load of hurt with Ken Chesbro, a now disgraced and convicted felon, former lawyer for Donald Trump, now testifying around the country against Donald Trump and the fake elector scheme that he helped invent and Mike Roman's role in it. So he's got a lot of problems. And so what they've come up with his lawyer, Ashley Merchant, is to file several weeks ago a motion which tries to drag Fani Willis and the indictment and the prosecution down into the mud and drag it through what looks to be a nasty divorce proceeding involving her special counsel, special prosecutor, Nathan Wade, and his soon-to-be ex-wife who cheated on him. And I only know that from what I've now learned, unfortunately, from the unsealing of the divorce records. So so people might be thinking, who cares whether he's getting a divorce or not? And the bad look or optics that you and I have talked about, and I did a hot take about this, is that Fani Willis looks like she's going to have to admit that she's in some sort of outside of work relationship or friendship, that friendship plus has traveled with Nathan Wade, and they've gone on some, relatively inexpensive cruises together and maybe went to wine country in Napa Valley together. I really don't care. None of that is a ethical dilemma for a prosecutor when you're having a relationship with somebody on that side of the V. It's not like a movie where she's, having a relationship with the defense lawyer and they've compromised the prosecution in some way because they're whispering to each other pillow talk. This is the person that works for her. So as Karen and our colleague said, is it an HR problem? I don't know, maybe. Is it a prosecutor grounds to dismiss the indictment problem? And that's the problem with MAGA. They always go too far. They don't just want to disqualify Fani Willis and Nathan Wade. They want to dismiss the indictment as a result. So it's great because they always hand an easy out to the judge like McAfee, like, okay, let's start from the beginning. I am not dismissing the indictment rendered by, and I think this is what's going to happen in mid-February at the hearing, rendered by a proper grand jury in Georgia on the backs of a special purpose grand jury that lasted for 4 months, that listened to copious amounts of evidence and decided to issue an indictment. And I haven't heard anything. This is where I think he's going to go. I haven't heard anything other than besmirching the reputation of the prosecutor and commenting on her choice of boyfriend that would undermine the validity and sanctity of that process or the resulting indictment. Now, should Nathan Wade at this point continue on the case, or has he been compromised because of this attack on him and by extension, Fani Willis? If somebody's got to go, it should be Nathan Wade for many levels of reasons. She can replace Nathan Wade. We and justice can't replace Fulton County District Attorney Fani T. Willis, who was elected by the people to do a job, and by all accounts, including our own, is doing a masterful job in going after Donald Trump. The new argument that Donald Trump's lawyers have raised, as you said, weeks late, joining the Me Too of the Mike Roman filing, which is they don't like the speech that Fani Willis gave to the historic Black church on Martin Luther King Jr. weekend, in which, without naming names, she called out her critics, claimed that she was, and I agree with her, that she was being attacked and her judgment was being attacked for hiring Nathan Wade, for having him work under her or with her on the case, because she's Black and her judgment's being questioned, and he's Black and his judgment's being questioned. And so she raised this kind of racial thing, from the pulpit of a Black church during Martin Luther King weekend. And so that gave Steve Sadow, the lawyer for Donald Trump, along with Jennifer Little, hold that thought on Jennifer Little, because she's embroiled in the Mar-a-Lago case as a witness against Donald Trump. leave that for a moment, but she did sign the pleadings that were just filed. There is a provision under the normal rules of ethics. There's nothing wrong with dating somebody you work with. In fact, I even posited on my hot take that if anything, based on how little he's charged on this case, given the scope of it, I think he's working harder and for less money because maybe he's having a relationship with Fani Willis. I don't think it runs the other way. I don't think he's slacking or overcharging the taxpayers of Georgia because he's in a relationship. I think he's working his three-piece suit off on this case, and if he's only charged $700,000. I mean, not to compare and contrast Fani Willis with Jack Smith, but she's got a 30-count indictment against 15 people and has fought off federal appeals about federal removal statute and has gotten 4 convictions already and 10 or 12 people already state's witnesses flipping on Donald Trump. She's done a great job, and so is he. But there is a provision. Again, this is optics more than anything else that Judge McAfee is going to have to sort through. Georgia Ruled Professional Conduct 3.8, Special Responsibilities for a Prosecutor, says in little g that except for statements that are necessary to inform the public of the nature and extent of the prosecutor's action and that serve a legitimate law enforcement purpose, a prosecutor should refrain from making extrajudicial comments, meaning outside the courtroom, that have a substantial likelihood of what? Heightening public condemnation of the accused. That's not what she did. She didn't get up on the bully pulpit or the pulpit of this church and say, and Donald Trump is a racist and I'm going after him and he hates black people, future jurors of Fulton County, and that's why I'm prosecuting him and he's disgusting. She didn't do that. She defended herself. And he's saying that she is blowing, talk about balls and gaslighting, that Fani Willis, is blowing a racist dog whistle against Donald Trump to whip up a prejudice against him by the future primarily, possibly all black or mostly black Fulton County jury against him, because that's what he's worried about. Now, look, let's put this in context. There's not a person of color prosecutor or attorney general against Donald Trump that Donald Trump has not called a racist, completely misunderstanding and misapprehending what the term racist means. Okay. So Fani Willis, even before this came out, racist. She's black, I'm white, and I'm getting prosecuted because of that. Okay. No evidence of that whatsoever. And she didn't indict Donald Trump. The grand jury did. Alvin Bragg, New York, Manhattan district attorney, who happens to be black, who got a conviction, 17 count, against Donald Trump's organization for tax fraud a year and a half ago, and now has brought the Stormy Daniels business record fraud case. Racist. I'm white, he's black. I must be prosecuted because I'm white and he's black. Letitia James, New York Attorney General, who we talked about at length during this podcast and throughout the course of LegalAF in the last year. She's black, I'm white. That must be the reason I'm about to lose my business and be banned from the industry. It's always somebody else's problem. And if they're black, God help us, it's because they're racist and he's white, not because of his misconduct as indicted by multiple grand juries. Grand jury Mar-a-Lago indicted him. Grand jury Fulton County indicted him. Grand jury District of Columbia indicted him. Grand jury Manhattan Stormy Daniels indicted him. Right? This is 4 different grand juries that have indicted him in 3 different states. 3 different states. 4 different locations, sorry. It's all because he's white and the prosecutors are black? I mean, MAGA, and I read, and you do a great job of always catching up on all and scrape at all the social media posts from all the wackadoos that are in the MAGA party. I mean, the comments that they make about the justice system and E Jean Carroll's disgusting and she's a liar. The justice system has gone to hell and woo MAGA, MAGA 2024. I mean, I don't even understand what they're talking about. And neither, I don't think, do the independents at the middle of this electorate. He's not making, I'm going to say this and I'll wrap up Georgia. Donald Trump is not making any new voters. Okay, he is animating and activating the MAGA base, who can only vote one at a time and once. Okay, except when they commit voter fraud. That's them. But has he created any new ones to overcome the electoral advantage of the presiding the current president and his track record? No, in my view, no. And our moderates and independents more likely to vote for Donald Trump now? No, absolutely not. We just have to, we're buffeting up against this age issue with Joe Biden, which is quickly turning in his favor based on the unhinged performance of Donald Trump. So look, back to Georgia. Do I think that under this rule, she has violated this special prosecutor rule by making statements on the pulpit of the church? No. Do I think Scott McAfee is going to kind of scrunch up his nose a bit about their relationship and maybe suggest that Mr. Wade needs to exit stage left? Maybe. Is he going to dismiss the indictment in the middle of February because of all this, or assign a new special prosecutor or prosecutor? No. Is Governor Kemp, despite getting pressured by the GOP Republicans in Georgia, some of which are the ones that are being investigated and indicted for involvement in the fake elector scandal, is he going to succumb to that pressure and take her out? No. And I think in terms of the trial calendar, though, we're not going to see a Fani T. Willis-led prosecution trial of Donald Trump before late summer, and it's not going to conclude before the election day when people vote on November 5th. There's only two cases that have a shot of doing that. You and I have talked about at length. Jack Smith's case, if it gets up and running by May or June, could conclude based on the speed of federal cases and with a jury verdict prior to November. And I don't think there's anything in the DOJ manual that's going to stop him from trying that case. That in the box Department of Justice rule, that's about starting a criminal investigation. That's not about trying a case about one that's already ongoing. So I don't think that's going to be implicated. And then the one that you and I like, and of course Karen loves from her old office, which is the Stormy Daniels case, which is going to trial on March the 24th, probably by itself, and will conclude within 8 weeks or 9 weeks after that with a jury verdict.
So in terms of just kind of verdict, criminal case, and where we're going with all of this, you have the E Jean Carroll verdict, $83.3 million against Donald Trump. Next week, we should have the New York Attorney General verdict against Donald Trump in the range of $370 million to $500 million. And then we'll have a criminal case in March. We'll probably reach verdict by, late April? Before May, I think you'll have Donald Trump as a convicted felon. He will continue to be whining about all of this. And at the end of the day, Popok, as you just stated, this is independent grand juries. Grand jury 1 in Fulton County, grand jury in Florida, grand jury in Washington, D.C., grand jury in Manhattan. And then you didn't even mention the actual juries in some of the cases. Like an actual jury convicted the Trump Organization of over a dozen felony accounts last year, and you had Donald Trump's CFO plead guilty for tax fraud, Alan Weisselberg. You had a civil jury who heard the sexual assault allegations against Donald Trump in a federal trial back in May and found that Donald Trump raped E Jean Carroll and found Donald Trump defamed E Jean Carroll, sexually assaulted E Jean Carroll. The judge made it clear it's the same thing as rape in the universal sense of how the word is used. New York just has a technical definition. Another jury heard what Donald Trump did, observed him, and on a Friday issued a verdict in the amount of $83.3 million. So consistently, over and over and over again, in these situations, Popok, where the facts and data matter, juries are coming to the right conclusions, and we here at LegalAF are following that data and following those conclusions. And Popok, you mentioned, independent voters and how they're all observing this. This is why though MAGA Republicans are talking about the border over and over and over again. And it's worth mentioning right now, although we've done broader hot takes on it, the Supreme Court ruling that basically overturned what the Fifth Circuit Court of Appeal had done, which was preventing the Biden administration from removing this barbed wire fencing that was leading to the deaths of migrants. It was killing human beings. It was killing people. And there's a way, I think, and President Biden agrees, to be tough on the border while still preserving our values as Americans and not killing people and separating families and torturing individuals. And one of the things where politics meets law at the intersection of LegalAF is this, Senate deal on the border, which is the toughest border deal, bipartisan, Democrats and Republicans. President Biden working with people like Senator Langford and Murphy and Sinema and people we may or may not disagree with who have come together, Romney, Schumer, all coming together and putting together like the toughest border bill that really addressed everything on a bipartisan basis. And what does Donald Trump do? He orders the Republicans to kill this deal. The whole day he's been posting to MAGA Mike Johnson and others, kill this deal, do not do the deal. And meanwhile, what's going on in Texas? You have Governor Abbott and all these Republican attorney generals and governors basically trying to trigger like this PR scene where Biden sends the federal government in to remove the barbed wire fences, and then Governor Abbott puts his own forces against the Biden federal forces, and there's this conflict at the border, and they're trying to create these stunts, and in an adult way, President Biden's kind of rising above that and saying, hey, I'm trying to reach a bipartisan deal to actually address this solution. And all you MAGA Republicans are doing is trying to create these stunts and this kind of lawlessness. And by the way, when you have Amy Coney Barrett and Judge Roberts, the two right-wing justices on the Supreme Court, align with the other justices appointed by Democratic administration. So it was a 5-4 decision. And then a Texas governor, MAGA Republican governor goes, I'm not following the law of this Supreme Court. And in fact, I'm putting my own National Guard, and I'm going to treat my National Guard like it's my own militia and arm them against the federal government. I mean, I think independence, I think most Americans who crave normalcy and are solution-oriented, like I am, I go, hey, look, there's a bipartisan solution. Don't we want a solution? And go, oh, wait, no, Donald Trump doesn't, because he's telling people that he thinks it'll be good for his election if he whines about the lawlessness, And that's what this all is all about, just the whining over and over again. So I wanted to mention that Supreme Court ruling in Texas connected to the Senate border deal and connected to the broader point you were making there, Michael Popok, about these kind of independent voters. But I'll save the rest of that for the politics show. And let me just briefly talk about what's going on in the D.C. Circuit Court of Appeals. You predicted this, Popok, but a fairly easy prediction to have made that the D.C. Circuit
Although
Court
you challenged me when I did.
The D.C. Circuit Court of Appeals rejected Donald Trump's request for an en banc hearing. It's spelled E-N space B-A-N-C. It's a Latin term to hear the full panel of all of the judges who comprise the D.C. Circuit Court of Appeals. You can basically petition on extraordinary cases that they hear the decision by a 3-judge panel, right? So the way it works is federal judge Tanya Chutkan made the ruling imposing a gag order, a 3-judge panel by the D.C. Circuit Court of Appeals, which kind of supervises the district court, Judge Tanya Chutkan. They mostly affirmed the gag order. Some aspects of it they modified, but they mostly affirmed the gag order on Donald Trump. Trump goes to the D.C. Circuit Court of Appeals, the full panel, and says, hey, right-wing judges, you want to help me out here? Maybe we can hear this. And every single one said no. None of us want to even have a hearing on this. Rejected. So Donald Trump loses yet again. And then we talked about it.
I want to make a point.
I'm going to give you the full opportunity to just kind of,
Okay,
and then finally the D.C. Circuit Court of Appeals panel, as we talked about at the outset, they have not yet reached a decision on the absolute presidential immunity question. My prediction was it would happen before February. So, next week I would be putting it at the outer perimeter of my prediction of when we would get a ruling, by Thursday. But that's kind of the outer perimeter of mine. If it keeps going to the following week, I'll start probably having a little bit of concern of what's going on. And even if they ultimately were to rule that absolute immunity does not exist, which I think they will ultimately reach that conclusion, the delay is going to cause a problem if this keeps getting pushed further and further out. But Popok, I'll let you finish up with kind of everything else on that topic.
No, I didn't have much more than that. I think you hit it well. On the 3-judge panel, I am concerned. I thought it would come much faster. I said 5 days. The way that hot bench was against John Sauer for Donald Trump, I really thought they had already coalesced, having read the briefs, around where their decision making was going to be. And Judge Pan is such a forceful power among the three that I thought she'd kind of get this together quickly. Yes, understand the historical importance of the decision about declaring for the first time that there is no absolute immunity for criminal conduct of a then president. We don't want that precedent on our books and for our history. But she's having a harder time, as you said. As we both said, they're struggling internally, but eventually the perfection can't be the enemy of the good enough. She's got to get this order out, because I think everybody believes at the DC Court of Appeals level, based on prior rulings against Donald Trump from our indication of where their heads are at there, that it's important that the American people know whether Donald Trump is a convicted felon or not before November 5th. In order to do that, since Judge Chutkan's already signaled in her most recent ruling, finding that Jack Smith is not in contempt for having to continue to progress the case in a certain way. But she did say that, while I thought 7 months was enough time, 6 months is not enough time, and 5 months is not enough time for Donald Trump to prepare his case. And this case has been on ice, and a pin has been placed in it for over a month since the filing of the notice of appeal. So they got to get off the stick here and get this out if there's any hope. Okay, March is gone. There's not going to be an early March trial involving Donald Trump and Jack Smith. Just not happening. Alvin Bragg, yes, poetic justice. He's first to indict, first to try a case. Great. We'll take at this point, we'll take any criminal trial that's available at the moment. But we want this trial to get started and off the ground in May, June. And we're getting up there now. Forget alien canon. That case is not happening, and Judge Chutkan's not going to wait for that case. And to just clarify one thing that I see sometimes raised in chats, DMs, and other things to me and to the others, there is no world in which there are simultaneous criminal cases against Donald Trump. Due process won't allow that, and constitutional rights of the defendant won't allow that. So whatever case is up and running, that case has to run to conclusion, and then there's a little bit of a gap before the next trial starts. So if March 24th is Stormy Daniels, that it takes a little bit longer to pick a jury in New York than other places. And so you're talking about 8 weeks, March, April, May, and now suddenly, hopefully Chutkan's ready, May, June. Forget about Cannon. She's done. Mar-a-Lago is not getting tried this year because of these other problems that we just talked about. And then Fani Willis, not because of who she's going to Napa Valley with. That's not the reason, but her case would not even be, there wasn't even be a thought that it would get tried before August. And she's already said it's going to take her 7 or 8 months to try that case. So forget it. There's no up or down vote, if you will, prior to that. And the one comment I'll make about the en banc is that does have an impact on the Supreme Court should Donald Trump now decide to take the gag order issue, which I'm not sure he's going to do, up to the United States Supreme Court. Because, yes, the U.S. Supreme Court will review this sort of de novo, if you will, certain aspects of it, but there is now a 12-0 vote, if you will. No one on the DC Court of Appeals, no one wanted to hear this en banc and thought that the 3-judge panel led by Judge Millett got it wrong. Not one. You needed a majority to just even hear it, right? You needed 7 to vote for it, which would have been almost impossible. And then even if they wanted to hear it, they still have to, on the merits, they have to decide something. He didn't get any that wanted to hear it. And that will resonate with the United States Supreme Court if and when Donald Trump decides to take an appeal, which I don't think he's going to take, given that he's losing regularly on immunity issues and gag order issues. And I'm not sure he needs, although, I think the running theme on LegalAF the last few weeks is his legal team is terrible, does not give him proper advice, or he is his own strategist. Between him and Boris Epshtein, they make terrible decisions that no normal litigant would make. No normal litigant would think to take an appeal on given his track record so far and his losing track record. I'm on with Anthony Davis this weekend on the weekend show, and Anthony posited he's still the Teflon Don. There's still things that he can get away with. And I said, I don't see that anymore. I mean, he's lost on immunity time and time again. He's lost on gag orders. He's lost on jury verdicts. He's been indicted 4 times. He's not going to go 91-0, on his indictments, on his felonies to win this case. We are seeing justice and I'll leave it on Robbie Kaplan's comments about E Jean Carroll. We are watching the justice system at its best and a jury system at its best. It takes time. I've got a case that's like 9 years since it was filed that hasn't gone to trial yet. It happens. But we'll continue to hold people accountable here on LegalAF. We don't blow smoke or sunshine. Ben and I certainly don't. Karen and I don't. On what we do.
Yeah, Ben and Popok don't either. Popok, they say the greatest trick of that the devil ever played was convincing the world that he did not exist. I think the greatest trick that authoritarians and people like Donald Trump have ever played is convincing the world that they don't lose. Donald Trump's a loser. He loses over and over again. Everything he's touched, he's not a builder, he's a destroyer. He's bankrupted every company he's touched. You go back to his history from the 70s and the 80s, it's filled with litigation and losing litigation, losing over and over again. And he would lose in Atlantic City. He would screw over contractors. They would sue him. He would try to delay it. He would end up trying to settle with them. Loser, 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 loser. Yet because he speaks like a petulant third grader about being a winner over and over again and goes, I'm a winner, I'm a winner, a winner, and just keeps on repeating that. It's a very strange thing that's instilled in the psyche, but authoritarianism and the propaganda behind it has always hoisted these types of people up to make it feel like their victory is inevitable and to make everybody else feel that there's just nothing you can do. So you just have to accept the inevitability of that. Those MAGA tactics that we would see and call out and expose in authoritarians abroad and historically and look down upon has reached our shores. And it's really sad to see. You talk about independence. I talk about even mainstream Republicans, independents, the pro-democracy community needing to unite right now against this threat. But for everyone, to your point, when you said Anthony Davis positive that this is the Teflon Don, this is a loser. This is a weak, unhinged, weird loser of a person who whines. He wasn't there when the verdict was taken. He storms out of courtroom. His behavior is that of a loser. You want to talk about courage? You want to talk about winners? You want to talk about real power? Look at E Jean Carroll. Look at her lawyer, Roberta Kaplan, and Roberta Kaplan's partner, Sean Crowley. You want to talk about winners? Look at Judge Kaplan, who has respect and dignity and controlled his courtroom. Those are the values of the United States of America, not this MAGA mess. And as we talk about the intersection of law and politics, that intersection is so critical right now, where you have this movement in MAGA that's built on trying to rip to shreds and tear down this delicate tapestry, these norms, these values that form our legal system, why you went to law school, why I went to law school, why we love our country, why we love our legal system, while we recognize its flaws and shortcomings. as we look to improve them, MAGA looks to just destroy it and replace it basically with Rudy Giuliani at the Four Seasons, whatever it is, next to the porn shop and the whatever, you know, and that right there is something that we all who love our laws, who love our democracy, need to be united on. So tomorrow, for all our LegalAFers, I did, and I'll announce it here, I did a 30-minute interview, Michael Popok, with former Arkansas Governor Asa Hutchinson. We spoke for 30 minutes about democracy, the state of our country, and I'm announcing it here. I announced it on our Patreon first, and now I'm announcing it here that everybody could watch it. It's going to be at 10 a.m. Pacific. And we really spent a long time going through issues where we disagreed, where we agreed. And I wanted to show how we can set aside differences and truly have a debate with civility. So I'm so proud to release that at 10 a.m. Pacific. 1 Eastern tomorrow. So make sure everybody checks that out. MeidasTouch.com/newsletter. It's where you can check out our new newsletter. Subscribe for free. You'll get emails from me and my brothers, other contributors. Maybe Popok will have you send a letter out to everybody on that newsletter list. MeidasTouch.com/newsletter. Folks, it was a good week for justice. Let's keep this momentum. Popok, Karen Friedman-Agnifilo, myself, and all of the contributors here at the Meidas Touch Network will be here with you each step of the way. Thank you all for your support. Thank you for being a part of this pro-democracy, law, and order community. And we'll see you next time on Legal AF. Shout out to the Meidas Mighty.